All right, I've got a message from Laura that says it's going. So, God, please be going. All right, thanks for your patience, everyone. Our apologies. Mr. Chairman, if you would give us a call to order, I will take a roll. We can adopt the agenda, do all the basics, and then move right into our rulemaking hearing.
Very good. We will call the meeting to order. Let's do a roll call.
All right, Mr. Garrison.
Here.
Mr. Atwood. Mr. Atwood is absent today. Dr. Jane. Yes. Mr. Bennett.
Here.
Mr. Mansfield.
Here.
Ms. Alexander.
Here.
Ms. Haston.
Here.
And Ms. Cole. All right, Ms. Cole is absent as well. So, we're good. We have a physical quorum present, plus one online. We're clear to proceed.
Very good. Let's approve the agenda for this morning. All those in favor say aye.
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 Those opposed, like sign. We have an agenda adopted. Are we going to start with the rulemaking hearing then?
Well, let's go ahead and approve the January minutes.
Okay. Very good. The January meeting minutes have been submitted. I will entertain a motion.
Motion.
Okay.
Approve.
Second.
Okay, we have a motion and a second. Further discussion? All those in favor of approving the January 2022 minutes, say aye.
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 Those opposed, like sign. Minutes are approved.
Thank you. Anna?
Okay, we'll go ahead and proceed to today's rulemaking hearing. This rulemaking hearing is called to order. My name is Anna Matlock. I serve as an Associate General Counsel in the Department of Commerce and Insurance Division of Regulatory Boards, and I represent the Tennessee Real Estate Appraiser Commission. Would the agency representatives who are present introduce themselves for the record?
My name is Michael Schulz, Executive Director of the Real Estate Appraisers Commission, and I'd also like to ask that each of the commission members please introduce themselves for the record, and we'll start over here with Ms. Alexander.
Michelle Alexander.
Jason Bennett.
Rex Garrison.
James.
You'll have to pull your microphone towards you.
Brett Mansfield.
Carrie Haston.
Thank you. Today is Tuesday, April 5th, 2022. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1B of Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. And also available by electronic means via Microsoft Teams, which can be located on the Commission's website, www.treagboards/regboards/public-meeting-information.html. On this page, the link for access to this rulemaking hearing via Microsoft Teams can be found in the chart located in the middle of the web page in the second row with the date 4/5/2022 and the location column under the words Nashville, Tennessee, labeled Connect. The purpose of this rulemaking hearing is to solicit comments on rule amendments to the rules and regulations of the Tennessee Real Estate Appraiser Commission. The proposed rules amend the requirements for continuing education. Presently, licensees are only able to take up to 1/2 of CE via distance education. Due to the increased usage and requirement of technology in a mostly remote environment, the Commission intends to amend the rules to allow licensees to take all CE classes via distance education. The education provisions for registered trainees, state licensed, certified residential, and certified general real estate appraisers have been updated to reflect this change. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of Secretary of State. Notice is given to the public for comment and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, then end of which time will be the effective date. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet to my left, located on the podium. Those members of the public wishing to speak and appearing via Microsoft Teams should put their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet and typed their name in the chat box. Is there anyone else that desires to offer oral comments but have not written their name on the sign-in sheet or typed their name in the chat box? Seeing that there are none, for those attending this hearing in person, I would call your attention to the table located directly behind me to the right. On this table, you'll find redlined copies of the rule amendments addressed in today's rulemaking hearing. For those attending on Microsoft Teams, you'll find a link in the chat box to the redlined copies of the rule amendments for today's rulemaking hearing. The notice of rulemaking hearing included the entire text of the proposed rules and were published on the Tennessee Administrative Register website on February 4th, 2022. Mr. Scholes, what additional notice was given to the affected individuals or groups?
An e-notify message was sent to all individuals who are set up to receive notifications from the Commission on Friday, February 18th. And additionally, a notice was posted to the Commission's website. It was noticed on the agenda that was posted on Wednesday, March 30th, 2022.
As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. So please limit your comments accordingly. I will summarize the substance of the rules into the record. Tennessee Comprehensive Regs and Regulations 1255-05-.043A is amended by deleting the language shall make up to no more than 50% of the total requirement for education cycle. And so that, as amended, Tennessee Comprehensive Rule and Regs 1255-02-.043A shall now read, courses given for continuing education via internet or distance education may be acceptable to meet the requirements of continuing education. Additionally, Tennessee Comprehensive Rule and Regulations 1255-04-.018 is amended by deleting the language no more than one half of. So that, as amended, Tennessee Comprehensive Rule and Regulations 1255-04-.018 shall read, a licensee or certificate holder may complete the individual's required continuing education credits via distance education. To date, I have not received any public comments via email pertaining to the rules for discussion at today's rulemaking hearing. Mr. Scholes, were any written comments received by the Commission office regarding these rules?
No, none that I'm aware of.
Are there any public comments from those present at today's meeting, either in person or via Microsoft Teams? Sign-in sheet is blank, and I do not see any names located in Microsoft Teams. Lastly, there are several measures I will need to adopt by motion and roll call vote as required by TCA Section 4-5-222. First, I will need a motion to adopt the hearing rule language as amended.
Motion to approve.
Second.
I'll go ahead and chime in. All votes during this rulemaking hearing will be by roll call.
Okay. Roll call vote. Mr. Garrison.
Yes.
Dr. Jane.
Yes.
Mr. Bennett.
Yes.
Mansfield.
Yes.
Alexander.
Yes.
Ms. Haston.
Yes.
Thank you. Next, I will read the regulatory flexibility addendum. Pursuant to TCA sections 4-5401 through 4-5404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small business. The proposed rules would positively benefit small businesses in the real estate appraiser industry by allowing current and future licensees the opportunity to take their qualifying education courses via distance learning. Therefore, the impact, if any, would be positive for small businesses and open opportunities to attract new customers. However, it is difficult to determine the precise number of small businesses that would be affected by the proposed amendments, as the Tennessee Real Estate Appraiser Commission does not directly regulate those businesses. Allowing an expansion of distance education may lessen financial costs associated for licensure in the industry in both the initial application process and during the licensure period. Distance education learning opportunities are growing and especially important during the increased usage and requirement of technology in a mostly remote environment. The Commission knows of no other less burdensome, less intrusive, or less costly alternative methods of achieving this purpose and objectives of the proposed rules. The proposed amendments would require minimal, if any, costs for compliance. Numerous states have adopted these qualifying education standards and those of the Uniform Standards of Professional Appraisal Practice, also called USPAP. Thus, the proposed amendments would take Tennessee rules consistent with federal standards and rules in other USPAP states. The Commission does not foresee an impact to consumers with the promulgation of the proposed rules. An exemption for small businesses would not be beneficial.
We'll entertain a motion.
Motion to approve. I'll second.
All right. Mr. Garrison.
Yes.
Dr. Jane.
Yes.
Mr. Bennett.
Yes.
Mr. Mansfield.
Yes.
Ms. Alexander.
Yes.
And Ms. Haston.
Yes.
Thank you.
I will now read the impact on local government statement pursuant to TCA Section 4-5-228. It states the Tennessee Real Estate Appraiser Commission foresees no impact on any local governments.
That one's easy. We'll need a motion again.
So move.
I second.
All right, we have a motion and a second. So, Mr. Garrison.
Yes.
Dr. Jane.
Yes.
Mr. Bennett.
Yes.
Mr. Mansfield.
Yes.
Ms. Alexander.
Yes.
Ms. Haston.
Yes.
Thank you.
I will now read the answers to the questions required by the Joint Government Operations Committee. All agencies upon filing a rule must submit the following pursuant to TCA Section 4-5-226 I-1. First is A, a brief summary of the rule and a description of all relevant changes and previous regulations effectuated by such rule. The answer reads, the proposed rules amend the requirements for continuing education. Presently, licensees are only able to take up to 1/2 of CE via distance education. Due to the increased usage and requirement of technology in a mostly remote environment, The Commission intends to amend the rules to allow licensees to take all CE classes via distance education. The education provisions for registered trainees, state licensed, certified residential, and certified general real estate appraisers have been updated to reflect this change. Section B states a citation to and brief description of any federal rule or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. The answer reads, Title 11 of the Financial Institutions Reform, Recovery, and Enforcement Act of 1989 requires that appraisers performing assignments and federally related transactions meet the qualifications set by the Appraisal Qualifications Board of the Appraisal Subcommittee. Section C states identifications of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or government entities urge adoption or rejection of this rule. The answer reads, the rule would affect current and future licensees and applicants. We believe that all affected would approve of the adoption of these rules because the proposed rules are beneficial to all industry members. However, it is possible a segment of individuals may oppose this rule if they are in favor of in-person classroom teaching opposed to distance learning. Section D states identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. The answer reads, there are no known opinions of the Attorney General and reporter or any judicial rulings that directly relate to this rule. Section E provides an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. The answer reads, there is no foreseeable probable increase or decrease in the state and local government revenues and expenditures resulting from the promulgation of this rule. Sections F, G, and H provide contact information for individuals. Speaking about the rules, I've provided my name and the name of Mr. Scholes. And the last subsection states any additional information relevant to the rule proposed for continuation that the committee requests. The answer reads, there is no known additional relevant information. I'll now need a motion to adopt the additional information for the Joint Government Operations Committee.
So moved.
A second.
We'll move into roll call. Mr. Garrison,
Yes.
Dr. Jane,
Yes.
Mr. Bennett,
Yes.
Mr. Mansfield,
Yes.
Ms. Alexander,
Yes.
Ms. Haston.
Yes.
Thank you.
That concludes this rulemaking hearing. Following this hearing, the rules will be put on a rulemaking filing form SS-7039 submitted to the Governor's Office for final review and then submitted to the Attorney General's Office for review and approval. Once the Attorney General's signature is obtained, these are filed with the Secretary of State and generally become effective 90 days from the date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Thank you for being here today. That's it.
Thank you, Anna. We can now go back to the regularly scheduled programming. Let's see, where are we now? We can move on to the legal report. Taylor?
Good morning. I hope everyone is doing well. We have the legal report before you to present. Before I start, are there any complaints you would like to discuss first, or are there any questions before I begin?
I think 1 through 4 have recommendations of closure.
Yes.
Sometimes we group those. Would entertain a motion to group those 4.
4 is close and flag.
Right.
Just to
Right.
differentiate.
And basically, we would adopt the recommendation.
Yes.
So moved.
Second.
Okay, we have a motion and a second.
I can read those numbers into the record.
Very good. Thank you.
Okay. Number 1 is 202-107-8141. Number 2 is 202-107-9691. Number 3 is 202-2000351. And number 4 is 202-2004311. And those are all to close.
Good. Thank you. We have a motion and a second. Further discussion? Hearing none. All those in favor say aye.
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 Those opposed, like sign. Motion passes. We will move into number 5 if you want to give us a summary.
Yes. Okay, so this complaint was submitted by a loan quality center after they believed that there were some errors that led to a possibly non-credible result. An expert review was conducted. In the neighborhood section, they found there was no support for property value trend or no analysis or summary for the demand supply section. They found that the highest and best use section does not summarize the analysis or give an explanation on how they reached their decision. The sales comparison approach section, the expert found that they applied the site adjustments in the wrong directions for comparables 2, 3, and 4. They used positive instead of negative. They found that there was no GLA adjustment summary and there was not credible adjustments used. In the cost approach section, they found that there were 2 different site values used with no summary or analysis of why there were 2 used or any explanation for their decision in that section. And based on these violations found by the expert, I was suggesting a consent order requiring continuing education over their minimum requirements, and then I was going to recommend for the commission to discuss and decide on the appropriate continuing education classes to be included.
Very good. Thank you. We will entertain discussion.
I've got a question.
Yes.
It says Loan Quality Center. Can you explain do you have any idea what that is?
That's just what the complaint listed their name as. They just said it was a loan quality center. They said that they reviewed it and they found that there were errors.
Further discussion or recommendations?
There's definitely a lot of errors that the reviewer picked up on here, really from market analysis, highest and best use, sales, and cost. Very, very extensive. And so council's recommendation is the consent order and then continuing education. Is that correct?
Yes, and then I was going to say you guys discuss which classes you think are appropriate to be included in the consent order.
At a minimum, a market analysis. Some of this, really, you could take it in a lot of directions.
This is also this will be the third consent order for this particular appraiser.
I'd added in my notes for sales comparison and report writing.
And yes, this will be their third. Sorry, I was just double checking.
I also noticed for there may be this is a violation course which gives idea about how to do appraisals properly so that appraisers are not in violation in the future.
So I've heard highest and best use, market analysis, report writing, and sales comparison as 3 courses being suggested. Would anyone want to make a motion?
Well, I know in the past, too, that we've entertained civil penalties with multiple recurring. With education.
So some of those are too old for us to be able to look at, but let me just see which years there were. Yeah, they both were too old for us to look at. We can't see either of those, so I'm not sure what was included in them.
It has been since 2011, so I guess that's worth noting as well.
Motion to approve?
For the three classes.
Yes.
Okay.
You repeat those.
Highest and best use market analysis, report writing, and sales comparison. Have a motion?
Is that feasible to take those within 180 days? I don't think so either.
Online now, can't.
I sort of think give them 180 days, and if they need more time, let them work it out with council.
You can give them up to a year to complete the courses.
And would this would not go towards continuing education, correct?
Correct.
In addition.
This is on top of their minimum requirements.
We have a motion to require the three classes, three highest and best use. I sort of highest and best use / market analysis. I'm sort of including that as one.
And is there a certain number of hours each one of these classes need to be, or
Probably need to apply that.
Yes, that's what I was going to suggest next.
I would say probably 7 hours each, at least, minimum.
Is the residential report writing course, is it not a longer course?
There's a 7-hour option. There's like a 7, a 14, and then one more.
Okay.
so we're looking at 21 total hours, 3 7-hour courses, and are there 7-hour courses out there for each one of those?
If there's not 7 hours, they can take over. It's a minimum of 7 hours.
They can use
If they
the
take
excess hours towards CE.
That would be a question for legal. If they take a 14-hour and we require 7, can they use the additional 7 hours as continuing ed?
Yeah, I don't think that'd be a problem. Are you wanting them to have to take an exam with these courses? Because if so, I don't believe that's included in the 7 hours.
No, not in a 7-hour.
Yeah.
No. And typically, I don't recall us ever requiring an exam.
Okay.
Maybe we should.
Ms. Haston, did you have a comment?
I just was curious if the extensive residential report writing course would cover all of this, if you did the longer course.
Is the most that's a 14.
We have a motion, no second, which the motion may need to be revised. How about if we let the motion die to a lack of second with a new motion, and I'll go ahead and make it, require 3 classes, highest and best use / market analysis, report writing, sales comparison, each at 7 hours. It must be taken within 180 days.
Second.
Okay, we have a motion and a second. Further discussion. Hearing none, all those in favor say aye.
Aye.
Aye. Those opposed, like sign. Okay, we'll move on to number 6.
I'm going to go ahead and read number 5 into the
Okay.
number into the record as well. That complaint number is 202-107-8401, and that was voted on for a consent order with a highest and best use / market analysis, a report writing course, and a sales comparison course, 7 hours each, to be completed within 180 days. Okay, number 6. This complaint was filed by a homeowner who believes that the respondent incorrectly labeled their property as structurally sound and missed termite damage. The respondent answered stating that they did not see any structural issues when they appraised the property and did not notice any termite issues with it. A termite damage company also missed the damage. It was only later found by an inspector. An expert review was completed on this appraisal. The expert found in the sales comparison course there was no summary of data verification. In the neighborhood section, there was no summary of how they reached their opinion of the neighborhood being stable, or no demand / supply summary. In the highest and best use section, they found that there was no summary of that opinion. In the cost approach section, they said that the cost approach is applicable but not necessary, and it was not just explained why it was not necessary or not used in that section. The expert found in the income approach section that there was no explanation of the exclusion of the income approach section, of the income approach. There was no issues, no credible violations found with pertaining to the complaint. So I was just recommending a letter of warning regarding the use path violations found by the expert reviewer, since the complaint was not credible itself.
Thank you. We have a recommendation by council. Further discussion.
I have a question. Why do some of these go to an expert reviewer and some of them don't? Like, it looks like 2 didn't go, but this one did.
So if they make certain complaints within their complaint, then that has to go to an expert reviewer. If it has anything to do with value or anything about the integrity of the complaint, those have to go out to expert reviewers to determine if there is any, as opposed to if it's untimely acts, that's something I can determine. But since I'm not an appraiser, it goes out to an expert reviewer just to determine if the appraisal is valid.
I don't think a report was written for 2, correct? Timeliness.
I guess I didn't see that, but in this case, I don't think, termite damage is not something an appraiser's going to see unless it's so extensive the house is falling down.
Yeah. They just were saying that because they missed that the report was not a valid report, and so it has to go out to an expert reviewer at that point.
Okay.
That's why I was not recommending a consent order or any class, since the complaint itself was not.
There is a mention on the report of appraiser claiming structurally sound. And those are like engineering type comments. So is there something that can be done to stop appraisers from claiming outside of their expertise?
I think without seeing the report, that may have been done. There may have been an extraordinary assumption, but we don't, have that information. A lot of the issue, same issue. An approach. There's not a lot of merit to the.
Mr. Mansfield, your microphone keeps switching off.
Sorry. So there's not a lot of merit to the original complaint, but there is that kind of reoccurring, issue. But the last was 2010. Was a letter of warning. I'd be willing to accept council's recommendation. Give them a pass here.
Additionally, we could also discuss a letter of instruction that wouldn't be reported to on their record if that's something that you guys would like to discuss, as opposed to the letter
Yeah,
of
we
warning.
get those confused, but a letter of instruction does not go on
Correct.
the registry.
As opposed to the letter of warning does.
Correct. Very good.
I'll make a motion that we provide a letter of instruction to the individual here.
Second it.
Okay. We have a motion and a second. Further discussion. In the letter of correction, will everything be spelled out of
Yeah,
issues?
I'll include that in there.
Very good. Very good. Further discussion?
And-
Hearing, go ahead.
Sorry, I can read the number in before
Okay,
you go.
very good.
It's 202-108-0681 for a letter of instruction pertaining to the use PAP violations found by the expert reviewer.
Very good. Thank you. Hearing no further discussion, all those in favor say aye.
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 Those opposed, like sign. Motion passes. We'll move on to number 7.
Okay, so number 7 is an administratively open complaint. This was open after the respondent submitted a notarized property inspection affidavit for a trainee prior to the trainee being licensed and the respondent not being an authorized sponsor of the trainee at the time. The respondent explained that they accidentally filled out the wrong paperwork and they were trying to fill out a sponsor affidavit paperwork. They have since corrected that and submitted the correct paperwork. So I just was recommending a letter of caution regarding the affidavit rules, and that will not be reported.
Number 8 goes along with this.
Correct. Yes, that's the trainee in question for
Right.
number 7. I was
Is number
recommending
9
the
the
same letter of
same
caution.
too, or similar?
I'm sorry.
Is number 9 similar also?
Yes, so that one's a little different, just based on an email that they included with their paperwork, but it's the same issue.
We'll hit 7 and 8, and then we'll jump to, I guess, 9 and 10.
Yes.
Very good.
Yes.
Motion to accept council's recommendation on 7 and 8. Can we do that?
Second.
Okay.
Okay, I'll go ahead and read those into the record.
Thank you.
Number 7 is 202004321. Number 8 is 202004331, and those are both for letter of caution regarding the affidavit rules.
Thank you. We have a motion and a second. Further discussion? Hearing none, all those in favor say aye.
Aye.
Those opposed, like sign. Motion passes. Thank you.
Okay, so number 9 and 10 are together, similar to 7 and 8. This was another issue where they submitted a property inspection affidavit. They submitted it only 4 days after the trainee was licensed, so they could not have completed the required 500 hours within those 4 days. However, this one's a little different because in that email, they included that they were under the belief that the trainee was able to be licensed at that point due to them attending and working with them on about 250 appraisals prior. So that created a potential unlicensed activity issue. However, the respondent's attorney answered the complaint and explained that what he meant by that was the trainee had just been shadowing him and had not actually helped on the appraisal, opposed to other than just helping them measure the property physically. So I was recommending a letter of caution regarding the affidavit rules as well as rules pertaining to unlicensed activity for both 9 and 10.
Thank you.
The appraiser completed 250 appraisals in 4 months.
That's what they stated, yes.
So you don't have to be licensed to assist in a report. I mean, you can have office staff that are, as long as they're in the certification. So what am I missing here?
His email had just made it seem like he was actually doing the appraisals with him. He was saying, I think that this, based on his work on the appraisal with me completing it, means that he's able to be licensed despite only being licensed as a trainee 4 days later. So it made it appear that he was actually partaking in creating the appraisal and creating the opinion of the appraisal, which would possibly be unlicensed activity.
I think it's mainly having to get the 500-hour affidavit to be able to go out on their own. Is that correct?
Correct.
Yeah. So they just did get their trainee license, and then, what was it, 4 days or 4 months?
Yeah, and then the email they included in
Yeah.
that insinuated that the trainee was doing actual appraisal work before being licensed. They clarified that's not what they meant, but that's why I just wanted to include that in the letter so that there was no
Well, he could
confusion
have
going forward.
could have assisted and gone out on inspections without doing unlicensed activity, but you don't get credit for it until you're
Exactly,
a,
Yeah, correct.
Right.
a trainee.
It was the wording of how he did it that
Okay.
created the
Yeah.
possible issue of that. That's why I was just wanting to include in there so there's no issues going forward. That way he's aware of the rules.
I make a motion that we up council's letter of caution.
A second.
Okay, we have a motion and a second. Further discussion.
9 and 10.
Yes, that's what I was going to say. This is for 9 and 10. The 10 is the trainee. And
Let's go ahead and read it.
yes. Okay, 9 is 202-003-501, and 10 is 202-003-511. And these are both for letter of caution regarding the affidavit rules as well as the rules pertaining to unlicensed activity.
Very good. Thank you. We have a motion and a second. Further discussion.
The letter of caution, do you mention also some concerns about the ethics of the situation? Because some people may say, okay, if commission dismisses all these doubts, they may just want to try and keep submitting these type of affidavits in the future. So we don't want to set a precedent that it's okay and it'll be dismissed. This
yeah.
should be taken quite seriously.
If you want that included, that's something that I can definitely include in there.
Thank you.
Very good. We have a motion and a second. Hearing no more discussion, all those in favor say aye.
Aye.
Those opposed, like sign. Motion passes. Moving on to 11.
Okay, so these are represents now that we're getting into. For 11, this is for 20190900591. And so in this situation, this had previously been presented, and it had been noted that the respondent was offered a conditional dismissal that they turned down, and then they got a consent order. However, I spoke with the respondent, and they explained to me that they were not intending to reject the conditional dismissal. They were just asking questions about the classes that were included in the conditional dismissal. They never heard back from the person that they contacted, so they weren't sure what was going on. Then they got the consent order in the mail. They reached back out about that, never heard back. And so then it's been about almost 2 years. And so they were under the belief that the complaint was closed until I reached out to them. So I was recommending that that you reauthorize me to offer them the conditional dismissal with whatever classes you think are appropriate based on the information found in the expert review.
Very good. It is the conditional, what is it?
Conditional dismissal.
Dismissal. When that's communicated, how is that communicated? Because we've had a few over the years that just don't accept it, and it's almost like they don't understand the opportunity that they have.
Yeah, I think the most issues I've seen with them is that they're not getting the opportunity to have their case presented in this. So they if they don't agree with what the expert found, that's what tends to lead them to be rejecting them. It's explained that this is kind of the opportunity just to take a class. It doesn't go on your record. It's like a one chance try. I email them out, and I also mail them out, and then I will speak to anybody on the phone. I can't speak to how previous councils had handled it, but that's how I handle it. But this person was very receptive and reached out to me immediately once I reached out to them, despite it being 2 years. So I think that they wanted to move forward with the conditional dismissal. They were just confused, and I think it just kind of led to a mishap in this particular complaint.
Very good. Thank you. Further discussion or I would entertain a motion.
Motion to accept.
Okay.
Second.
I have a motion and a second. Further discussion. Hearing none, all those in favor say aye.
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 Those opposed, like sign. Motion passes. Number 12.
Okay, number 12 is also another represent. This is for 201-806-2301. This has been represented a few times. And basically what happened last time was you had voted for the original expert reviewer to re-review the report and gave them certain certain lines to stay within when they were re-reviewing it. However, that expert reviewer is no longer completing reviews for the department, and we do not currently have someone that is able to conduct a second review on this. So we're in the process of procuring additional expert reviewers, but at this time there's no one that can do it. So I just wanted to re-present it to you to discuss and see how you're wanting to move forward on this.
Throw this out. Would it be an option for one of the commissioners to review it?
Yes.
Are there any volunteers?
Nominate Rex.
Well, I will say this on this particular one. I've been vocal from the first go on it. I'm okay. The issue is the one that reviews it will have to recuse themselves during discussion. Is that correct? Or can I vote on
if
it?
you're the expert reviewer, then yes, recusal from any sort of opinions thereafter would be involved.
Or anyone else? I'll do it in default, but
That's something we need to decide here, I assume.
yeah, I think they're trying to get some closure to this case.
Yeah.
Outside of being vocal, is there any conflict of interest?
I don't have any conflict of interest other than speaking out on this from the get-go.
I don't mind to do it either as well. So however y'all want to proceed.
I believe we do have a valid motion present. There has yet to be a second. So that's where we are at this point. We can, if it's a second for Mr. Garrison, then we'll go ahead and move to a vote. If the motion is withdrawn, then we'll start over.
I'll withdraw the motion. There you go.
Also, just to note, this is connected with number 13, which is the same. So it's going to be the same situation basically on both of those.
Acceptable to do it. All right. Motion that Mr. Mansfield completes the expert review.
I'll second.
I'm going to go ahead and read number 13 into the record as well, just so
Thank
it's
you.
for both of those. Number 13 is 202-000-2971. And this is for Mr. Mansfield to re-review the appraisal.
Very good. We have a motion and a second. Further discussion?
I have a question. Is the use of words appraisal, is it dictated by the laws, or there's increasing number of CPAs and computers seems to be using this word, and that creates a lot of confusion about who's allowed to do appraisal and who is not allowed to do valuation type activities?
I think, as far as the appraisal law, it's fairly clear on what exemptions there are. I've run across over the years accountants trying to do some valuations, and I think they're pushing the envelope. And when it has to do with real property, it really falls under this jurisdiction. Do we have a motion and a second? No further discussion. All those in favor say aye.
Aye.
Aye. Those opposed, like sign. Congratulations. Thank you for doing that.
That's the end of the legal report.
Very good. Thank you. We will move on to the experience interviews.
Yeah. Does anybody have any comments on any of the experience interviews? I believe everybody on the list is approved. Mr. Atwood, I did speak with Mr. Atwood this morning. He wanted to reiterate that he had approved everyone that he had interviewed. I believe that is reflected on the report.
Got a comment. Jennifer Robinson, I sent you an email. I'm not sure I received anything. Did that go to someone else? Did anybody else interview her?
What was the name again?
Jennifer Robinson.
Jennifer Robinson. Let me ask Will. Will, did that go to anybody else?
Michael, I don't have a record that it went to anybody else. I can resend it if required.
Okay.
Okay. Sorry about that. We can move forward. With a motion that everyone accept Jennifer Robinson.
Based on an experience interview with her?
Yeah.
Okay, sure.
Very good. Entertain a motion to accept all the experience grading excluding Jennifer Robinson.
I've got. I'm sorry.
Go ahead.
One more. John Schmidt. We're still working, so
okay.
He's only typically yes based on resubmission. Okay. I don't know if that needs to be clarified or not, but otherwise,
yeah, we've done that before. Probably be cleaner if we pulled John Schmidt out and do it as a separate motion since it's a conditional. Okay. So we'll do a motion to accept all the experience grading excluding Jennifer Robinson and John Schmidt.
Second.
I have a motion and a second. I made the motion. Commissioner Alexander seconded it. Further discussion? Hearing none. All those in favor say aye.
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 Those opposed, like sign. Okay, and John Schmidt.
And Ms. Robinson. So I'll make a motion that conditional approval pending an additional meeting with them.
Okay. Very good. I'll second. We have a motion and a second. Further discussion? All those in favor say aye.
Aye.
Aye. Those opposed, like sign. Very good. That completes the experience. We'll shift over to education, and I'm going to have to recuse myself on one of them.
And just to close that, Will's going to be in touch with you with any additional information you need regarding those two interviews. Thank you.
So I'd like to make a motion for the education. The staff have reviewed the materials, full course content submitted for all of these courses listed on our report. And we would encourage all the vendors also to provide full materials from the beginning, so there is not a lot of back and forth with the staff in terms of what's required for course approvals. All these which are recommended for approval have been reviewed and found satisfactory. So I move that the courses on the list be approved by the Commission. Thank you.
Thank you. We have a motion. Is there a second?
Second.
Okay, a motion and a second. Further discussion? Very good. All those in favor, and please note I'm recusing myself on this one as I'm involved in one. All those in favor say aye.
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 Those opposed, like sign. Education is approved. Right into the director's report.
Well, as you can see, thank you, sir. As you can see, I only have one item on my underneath my report. That is the financial data. Most of, I think, the things that I would want to talk about or would need you all to talk about will be coming up later on the agenda. So have left them in more appropriate places. But is there any questions about the financial report that you see?
I have one.
Yes, sir.
It's in February, and it's a other expense, but it seems higher than all the other months. Not quite sure what that one is. Sort of ranges from about 9 to 27, and then it jumps to about 65,000.
Yeah, that it could be computers. We did buy new computers and equipment for the AWS working situation that we've been under and that the state has adopted. So that could be reflected in here as well. I can look into it in more detail and see if I can find a line item or at least a little bit more of a detailed description. If
I
you
was
want.
just curious because it seemed to be higher than all the other months.
Second. I might be able to pull that up right now while we are here. Also possible that and this is kind of what I thought, but I wanted to verify it. It's possible that it might be an ASC registry fee as well. And, those things come due, but I am not able to gain access right now to the finance files. So I'll need to probably hardwire in. I can get back to you
That's
on
fine.
that.
That's
Okay.
fine. It was more curiosity. Very good.
Might be useful to have past 12 months to notice any cyclicity or seasonality for future reports.
Let's see, the past 12 months.
If it's the ASC final reports, it'll.
Okay.
Sorry, your microphone was not lit for most of that. Look down at the bottom, Dr. Jane. The corresponding columns show the historical period. They don't go into any sort of detail. It's just totals for the month. So it does not. It wouldn't break it out by month, but we at least have the corresponding month. Yes, sir.
Very good. Thank you. I don't believe we have to vote on that, do we?
No, sir.
Very good.
No, sir. And that takes us to the new business section. And we had a request for a complaint process discussion. Anna or Taylor, do either one of you want to start this off? Okay. So at this point, I believe there's Mr. Cross in the audience who had some questions about the complaint process that we'd go ahead and entertain.
Very good. Step to the podium and identify yourself.
All right. My name is Creighton Cross, Knoxville, Tennessee, certified general appraiser. The information that we had earlier with the complaints was very informative, and it helped me tremendously understanding that process. And thank you all. I think everything that was done was very fair. So get that out there. I think that was handled very well. My line of work, I cover a big area, trained a lot of appraisers, get a lot of phone calls from people around the state who have had complaints filed against them. In a lot of instances, they're saying those are frivolous complaints without merit. Issues that have been brought up have been ranging from appraisers being on the property too long, appraisers not being on the property long enough. Obviously, value issues are becoming an issue. We're in an erratic market, seeing a lot of appraisal waivers, appraisal contingencies that are driving consumers to not understand the process of what we're here to do. As stated on the state website, I think that what we're here to do is protect the public trust, and I think this board does an excellent job at that. Legal has been very helpful in helping me understand some of this. I have some questions, if I can, to help myself understand this. Some of the items that you mentioned for, I don't know if it's reprimand, but you said a consent letter, a letter of warning, letter of instruction, and a letter of caution. Can I get like a definition or understanding of each of those, please?
So for the appraiser commission, the way that the letters work in this scenario, we have letters of instruction. Those are reserved for, I think, an example today, something that wouldn't be proved as like a substantial error that the commission would like the individual to be more aware of. Letters of instruction do not go on the appraisal subcommittee, the National Registry. The next level of discipline would be a letter of caution. We're reserving those mostly for the affidavits issues, but also when we received, and also for the when the individuals are unable to pay the fees for the registry and continuing education. Those issues are letters of caution, and those do not go in the National Registry. What begins going on the National Registry would be a letter of warning. Letter of warning means that there has been a violation, but the violation, we don't believe, raises to the extent of a consent order where we're requiring an individual to do some type of corrective action. So letter of warning does not require you to do anything. A consent order, those matters are resolved for, I would say, the more serious violations that we have. This board tends to favor consent orders to provide education courses in lieu of civil penalties, but those are available. Also, consent orders at the most egregious kind of level would be a suspension or a revocation of a license. So anytime where we're asking an individual to complete something where they can either say yes or no, that's going to go out via consent order because it's merely at that point an offer of settlement. So the additional form of a discipline that we have with the Ural State Appraiser Commission are the conditional dismissals. These conditional dismissals are reserved specifically for individuals that have not had any kind of disciplinary history before the commission before. So those are also sent out for review by expert reviewers. The reviewers, if they have findings, they'll provide those to us. And similar to the consent order, we'll recommend education for those courses. But the difference is that this education can count towards your continuing education. And then once that's completed, the matter is considered to be dismissed. It's not a violation. That's not going to go on the National Registry. So if an individual decides to accept conditional dismissal, that would be the end. But if they say no, then the conditional dismissal is going to be put on the legal report before the commission to make a determination. Kind of in the circumstance that we had here, if an individual disagrees with the findings of an expert reviewer, that would be a situation where you bring it. Also, if the expert reviewer doesn't find any violations, then there would be like a recommendation for dismissal. Don't forget anything.
With that, would any situation where there was trying to think of exactly how that would go, is there any situation in the conditional dismissal where it goes to a formal hearing if it's declined by the applicant or the person in question?
So if an individual doesn't accept the offer of a settlement for a consent order, then the next process would be a contested case proceeding before an administrative law judge. If it is for unlicensed activity, that's going to be an administrative law judge sitting alone. It's the only topic that this commission has given them the authority to sit as. But any other violation, the commission will sit along with the administrative law judge.
That helps tremendously. Thank you for that. I think that is something that should be, I've not been able to find it in the website. I think that's something that the appraisers in Tennessee should be aware of. I stay pretty involved, and I did not know that process. I did not know all of these different levels of, I don't know the word, but I didn't all an option. I don't know if that's something added to the website to help explain to the appraisers the process so that people know exactly. It sounded like there were two cases where the appraiser did not know exactly what their penalty was, and it went over time. And in a situation like that, I'm just curious if that's something we could add to the website to help educate the public. I couldn't find it on the website somewhere that I'm just not direct me to the.
I don't believe it's on the website, but we can discuss that with executive director and assistant commissioner and my chief counsel.
Thank you very much. So with consideration of the complaints, people have been calling me about frivolous, without merit complaints, issues like I mentioned. I mean, not hitting values, not having proper apparel. It just appears that a lot of times this is an anonymous complaint. I don't know if there has to be a name associated with that. But if there's an anonymous complaint, it's almost like you're guilty and you don't know your accuser. A lot of times it appears that they don't understand what is being accused. One of the issues that we keep seeing that I've had some people reach out is value. And in the situation where you're not an intended user of the appraisal report, do those get dismissed automatically? Or is it still subject to a potential expert review?
So anonymous, I'll start with anonymous complaints. We accept anonymous complaints across all of our occupational licensing programs. So because a matter is anonymous doesn't mean we're going to dismiss a matter. So if the complaint has enough information to move forward, then it's going to be handled in the normal process that we have. As far as matters related to value, typically those complaints, we don't have findings for those, but we cannot essentially bar a certain amount of complaint from coming in, as it does relate to the commission. And at times when an individual may be making a claim of value, when a matter may be sent out for expert review, there may be additional issues that are found at that point as well. So the only matters that are going to be like initially closed on the front end are going to be matters that would not fall within the jurisdiction of the commission, meaning that it was probably intended for another board, or possibly a board from another jurisdiction, or also if there's insufficient information. So if we did receive an anonymous complaint where we didn't get enough information about who the person is, how to contact them, then those matters can be closed because we can't move forward.
All right. Thank you.
Great. And if I could just interject here, it doesn't matter if they're an intended user or not. So a reviewer could be reviewing an appraisal, and they could send it in anonymous if they wanted to. Anybody who gets their hands on the appraisal can file a complaint.
Just know in USPAP, we are very clear about intended
Correct.
use, intended users, who has access to the appraisal report. We can't keep our appraisal reports from getting out there. And so it seems to limit the protection that we're offering our appraisers. It just seems to really hamstring and handcuff the appraisers to this liability that could go on forever. Obviously, we have statute of limitations on liability and such, but in this situation, I don't know that we are doing a service for our appraisers and the public by not having some type of vetted system that would allow for a non-intended user of an appraisal report. I mean, anybody can just file a complaint at that point, and it may go that way across all regulatory boards. Not that familiar with it. I just know if you Google, complaints on appraisers, it is a literal encyclopedia for dummies on how to file a complaint for appraisers. But if you look that up for any other profession, it's much more difficult to file that complaint. Our situation is that we are unbiased, impartial, providing supported documentation for our appraisal reports. And for somebody to just disagree on value, or they didn't like the way we dressed, for those complaints to go in front of a regulatory board and then that file automatically get filed in some type of expert review, that seems to be a little bit egregious. It's not a barrier or a protection for the appraiser. It makes me nervous to just do appraisals anymore. I can't do my job for the overregulation and liability issues that are coming on the appraisers. And I mean, I could voice my opinion on the overregulation across the board and what's happening to appraisers nationwide. But one instance, we say we need more appraisers. The next instance, we're regulating appraisers to death. And I do believe that like the penalties that have come out of the board are very fair. I think it's very fair. I think that's excellent and it's handled appropriately. I just want to know if there's anything that we can do in the state of Tennessee from a regulatory board to maybe create a committee, to create some type of education platform to help educate the consumer, one, on how this process is supposed to work, when is a egregious claim, when is it proper to file a complaint, and maybe there's something that we can do to protect that appraiser too. Texas has the Texas Real Estate Appraisal Board. They have it's not a bill yet, and I've talked to them on yesterday, but they have a website that I've provided to Taylor that they're accepting public comments on appraiser complaints made in bad faith. I think that the state of Tennessee Appraisal Board should look into this, try to follow up on what they're doing. I think California has a similar discussion going on now, where it's apparently allowing a board or some type of committee to review these complaints as they come in for merit. And I understand we have some of that currently, maybe, but I'm seeing or hearing that a lot of these complaints are going automatically into these USPAP compliance reviews. And apparently Policy 7 from the ASC is where the state board regulates the review process and the reviewers, contract reviewers. My firm was at one point a contract review firm for the state of Tennessee. It's been 10 years ago. We had a USPAP instructor on staff that did these. And it was from what I remember, I didn't do the reviews personally, but what I remember, it was a pretty fair process. You got the appraisal, you got the work files. Sometimes you could have a discussion, but it was a confidential agreement. The appraiser doesn't get the opportunity to see their review. They get a summary of USPAP issues. And in that situation, say it's a standard rule 1 development issue, that appraiser doesn't know maybe where they missed that or what actually that was a violation of. It's not clear. And in that situation, I think there should be some policy. It's my understanding that there's a client confidentiality situation between the board and the review appraiser, but I think there should be a confidential, some type of review provided to that appraiser so that they can actually see what they've done wrong. If we are here to try to educate and protect the public, but the appraisers are being complained on and they don't know where they made a mistake in their appraisal report, then taking a report writing class or direct sales comparison class is not going to help that appraiser. We've all had these education classes. Some of them are more beneficial than others. In person, in my opinion, is more beneficial than online. We don't know that that appraiser is actually getting the education they need to correct the complaint. And, I've seen, just in standard banking appraisals, we get kickbacks on reviews where we're making the same mistake over and over and over. Well, USPAP is pretty clear, black and white. But I do believe that there's some very serious, we can't be perfect. USPAP does not require perfection. And so I do believe that there needs to be some type of policy or committee or rule that would protect the appraiser from these frivolous complaints. And just as Texas has proposed this, they're reviewing as a board, we're creating a committee to review complaints made in bad faith. And that specifically talks about and I'll just read it to you. Texas Appraiser Licensing and Certification Board is now considering how to investigate complaints against appraisers made in bad faith, filed for the purpose of harassment or to gain competitive advantage. If anybody's in social media forums, there's real estate home inspection appraisal social media platforms where literally somebody complains that appraisal came in under contract price. The immediate commentary, 200, 300 comments say, turn that appraiser into the state, turn that appraiser into the state, turn that appraiser into the state. They need to understand that there's a reconsideration of value option. They need to understand that there's a lender client that should be the one requesting that. And I just don't think that we're doing a good job of educating the public, in particular our fellow real estate professionals. And I think that's something that, you know, we would like to add. I take my job very seriously, and I've seen some complaints that have been just absolutely egregious just because somebody wasn't happy that day. I don't think that's fair to the appraiser or the public. So I don't know if there's additional discussion, thoughts. Is that something that...
Well, something as we did as a board, Fannie Mae was continually sending in just letters saying, hey, you know, we had an issue with this, and, you know, we stopped that. You know, if they have a problem, they need to file an actual complaint. On the conditional dismissals, I just want to go on. We as a board don't vote on those. Those come from legal.
Right.
So that doesn't have anything to do with us. I agree with you. I feel like it'd be extremely helpful and important because we have looked at some recommendations in some reviews in the past that people who know a lot more about that on this board than I do felt were completely incorrect. So when you get a conditional dismissal, you know, one, it makes it go away. I understand that, and it doesn't show up on your record. But who did the review? What did it look like? Where's the deficiency? If we are allowing the appraiser to see where the actual deficiency is, the only benefit to that is they potentially don't make that mistake in the future.
I think that's huge. It's my understanding there's a confidentiality client relationship.
The expert reviews, they're considered attorney work product. So those are not provided to respondents in that case, because that information is what we would use if the matter, for example, was to not be settled and would go to a hearing.
They would get a copy of that in disclosure, though, at the hearing.
They're, again, I would say that's an attorney work product, so that's a decision that I'm saying that is probably going to carry through the hearing. I'm sure their opposing counsel would try to obtain a copy of the report, but it really just depends on the circumstances. But we don't give them out to individuals outside of an intention of litigation.
That's across all regulatory boards? Is that with all the boards? They don't give those any kind of...
Yeah, right. Our investigative reports are not provided to individuals because those are the reports that we request as the attorney, and they provide us the information that we use for our complaints and our consent orders. And ultimately, if the matter goes to a hearing, that's going to be something that we would use when we're talking to the expert reviewer on direct examination, or whether an affidavit is going to be filed. So certain documents are considered privileged, and that's going to go across the board, even if it's not here at the department, just generally in the legal field.
How about after, say, someone accepts a conditional dismissal? Could you send out the information after the fact that specifically identifies the issue? If they've accepted even a letter of warning, whatever it is, so they can identify what the issue was, so they could potentially prevent it from happening again?
So my question would be, for example, if we're looking at the reports that were before you today, is the information in the summaries not considered a sufficient amount of information to tell an individual what is wrong with their report?
Sometimes it is, sometimes it's not. And over the years, we've gotten different information based on the attorney presenting it. We've discussed in years past about creating almost a uniform review and identify certain areas that we would like to see as a commission. And that way, when it goes to a reviewer, they understand the scope of their review, and what information they're looking for, and it's consistent no matter which reviewer you may use. And that was discussed probably, well, it was pre-COVID, but it was discussed identifying some of the main topics on the front end, and that would be redacted then for the information that we receive. And then that way we get more detailed information, because what we see is actually a summary of a summary. And sometimes details that we may be looking for as commissioners isn't communicated. And that's sometimes why we go back and say, hey, can you talk to the reviewer? Can you get this looked at again? Different things like that. And I think it would be, as far as the communication between the commission and legal, would be helpful if we're all speaking the same language. And it may help, and it's a consistent report.
My question would be, so if we're talking about that kind of specific report that we're looking at, would that be across the board for any license structure that we're having? So is it the same, going to be the same for certified residential, the same for certified general? Okay, so that would be, and I guess also, I understand like the general base information, we can definitely discuss that, but also when a complaint comes in and someone is mentioning about a specific action, would that be in, I guess, a separate section of their own that would be outside of the general information we're looking for? Because we're really at the beginning, when we're looking for these reports, we're trying to have the issues that are brought up in the complaint solved. But
Right.
During that process, I think it would be intuitive for the person that is doing the review to also see if there's something else that is missing. And I think that comes also through the connection of most of the complainants that we have are lay people like me. So individuals that are not part of the industry. So if they're looking at one issue here, what if there's like this big glaring like light that's flashing that they don't know about? So I guess my question would be, how do we draw those parameters and make those lines?
And that goes back to educating the public, protection of the consumer, protection of the appraiser. I think and forgive me if I'm not understanding still, but what it seems like you're saying is if there's a complaint on highest and best use, somebody saying the person didn't analyze highest and best use or just a sales comparison issue, that review, expert review, is supposed to look at everything in that report for USPAP compliance, not just the specific complaint, but for you to uniform that in this platform, it would be really difficult to make that uniform because the complaints are on different issues.
That was just like my question that I'm thinking of in that particular circumstance. So
at this time, could I ask, is there an ask by the commission for us to evaluate or reevaluate some process that we have here regarding this?
I've got a question. So is the review process, is that state law? I mean, is that something that is in state law, or is that just a procedure that is utilized?
To send it out for expert
Just how the entire review process works from, because Creighton's right. I mean, I don't, in my time here on the commission, I mean, we may have had a handful of complaints that have been USPAP compliant, but 90% of them start somewhere else. And so is there a way, I mean, is that in Tennessee state law, where do we have any flexibility there basically?
So we, enter for like our expert reviewers, we have contracts and we tell them exactly what it is that we're looking for in an expert reviewer. And once that individual agrees, then it comes down to the specific complaints that are brought to them. And then at that point, it really just depends on who the expert reviewer is in that circumstance and how they work. But the one thing that I would just say about all of this is like, if there's a conversation or there is an issue that you don't believe rises to the level of discipline that would be appropriate, in a conditional dismissal, you can say no. In a consent order, you can also say no. So there's always the opportunity to have that on the other end to challenge what has been said. So nothing that is being provided to a particular licensee is not anything that they don't have the remedy to fix in a form of our own due process, like what it is for available under the law. That would not be.
I think we need to be careful. I think when we send a review out for an expert review, it needs to be reviewed for USPAP compliance.
That's what
I think the question is, the ones that don't need to be sent out for expert review, that there is a better process in place potentially, because you might have one sent out that potentially doesn't need to go for expert review, and unfortunately then somebody finds 4 or 5 errors in the report. And I think
perfect report.
Right, there's no perfect report. I mean, everybody up here has reviewed reports, and I think it's safe to say probably 75% of every appraisal report you've ever reviewed, you can find something wrong with it.
Correct.
So I think Creighton's point is, how do we make sure we're, one, protecting the public and educating them on what to do and what not to do, and then, guiding our appraisers better so they have some comfort knowing that I'm not going to just get turned in for anything and then send it for expert review and somebody says, hey, he didn't see the termite damage. Me personally, that would have never gone to expert review because that's outside, and it will state in the report that the appraiser cannot find anything that is behind walls or just isn't readily available to see.
Appraisal is not a home inspection.
Correct.
It should be stated in the report.
Yeah.
Mr. Bennett, we are able to put together a list of kind of do's and don'ts. We've done this for home inspection. We could put together kind of a list of do's and don'ts or something for the consumer, but really we also would encourage every appraiser who goes out for a job to manage expectations and let their customers know what to expect. And I think that communication is vital. We can put something out, but we can't guarantee the reach.
And that's where appraisers as a whole fail, because there's not a good trade group that supports and represents them in matters like this.
And also, just to speak, so on it going out to reviewers, not everything goes out for review. Only 2 of the 12 went out for reviewers. It's just when they make a complaint of value or of it being a non-credible appraisal. I'm not an appraiser, so I can't decide that. So that's why those issues go out for appraisal. But if it's just basic issues as opposed to timeliness or unprofessionalism or things like that, that's something that I decide and then present to you. And you can decide on that. But they're only going out for value complaints or non-credible report complaints.
Is the appraisal review from these contract reviewers, is that open records law? Is there anything that would allow that to be opened up? Or does that, once it got to the
No, so the review itself is, I think, is its work product. So that what it would be found beforehand. And then it would be ultimately in some kind of litigation arena of whether it's disclosed or not. But I would, just like as a message or to you or to anyone that's listening, I don't think it's not our intention to be like, gotcha, like you didn't look at the termites or anything. But in a program like this where there are things that are very, very technical, we have to work with the circumstances that we do. And I think in instances when it comes to appraisers wanting some kind of, I guess like what it would be like an exhale of not worrying that you're going to be like held at the fire or something of the sort, that's not really what we're looking to do. It's looking at use PAP to see what is and what is not considered a substantial violation. And so in the matter of consent orders, those come before the commission. Like today, termites? No. But other issues, it's kind of hard to make those determinations on the front end. But the thing is that we are unable to, and I don't think it would be good precedent to bar certain complaints from individuals that have maybe have an issue with an appraisal practice, or if they have an issue with a real estate agent or a home inspector and those kinds of things, because when it starts to get very, I see those as very subjective and not objective. But at the end of the day, if it's something that you feel strongly about that you didn't do, there's a remedy for that. Also, I believe that our expert reviewers are able to look at things and be like, no. But I don't think that looking at an appraisal report and glossing over something that may be incorrect would be doing anyone of good service to miss that.
Also, off of that, if the complaint is not valid itself, that's something that I take into consideration when making my recommendation. That's why I didn't recommend a consent order for the one, even though use violations were found. So I think that plays a part in if the complaint is credible or not, or if they're making any credible allegations or anything like that. And additionally, if a respondent wants to turn down a conditional dismissal, then it will go on the legal report and it will go to the commission, and the commission can decide if they think the expert found actual violations or if there were credible violations found within that, and they can decide if it should be a consent order, a letter, or just close itself.
Once it goes to that open hearing, is that on permanent record with ASC?
The hearing? It just depends on the outcome of the hearing. So if the matter is dismissed, it would be on the National Registry because there's not a violation.
Okay. Thank you.
So,
one last thing, guys, I appreciate the education. I think that's very important for anybody listening, and I'm thankful that you took the time. Board, thankful for your fairness across the board. It's just something I take very seriously, and I know a lot of you do, and a lot of our appraisers in our state do, and our market is changing, and I just want to make sure that we get ahead of this and start looking at issues like this. But thank you all for your time.
Thank you. Move on to the next item of new business, below grade measurement guidelines.
Yeah, and if I could interject real quick, just for these next two items on new business, they're more of announcements, so to speak. There's not really, after reviewing them, there's not really any action that the board can take on these. So, discussion is, I think, in that sense, discussion is somewhat limited. But in this first item, Ms. Haston requested that this be on the agenda, so I'd like to turn it over to her. Ms. Haston? Calling. Well, let's do that. Let's move to the PAVE discussion. and then we can come back to the below grade.
Yes, the PAVE report was submitted to Congress. It was done through a task force by President Biden. Basically, we have included it in the reports for information purposes. There's no action that we need to do at this time. However, there may be some action items at a later date, but it's more for information purposes right now.
Okay. Caleb is in the process of giving Ms. Haston the call-in number. So if you guys just want to hang tight, this should only take about another minute or so. We could. Oh wait, she's just come on.
Unknown participant is now joining.
Ms. Haston, you can hear us now?
Yes. Can y'all hear me okay?
Yes, ma'am. We had while in the interim, we covered the property appraisal and valuation equity report that was on the agenda. And I don't know if you heard me or not as we moved into these items, but I had expressed that after reviewing, we have realized that there's no action for the board to take on these. So these new business items are more like announcements and any sort of additional information you might want everyone to be aware of. So at this point, we can turn it over to you to begin the below grade measurement guidelines item.
Okay. All right. I don't know if anybody's taken the ANSI courses that are familiar with the ANSI guidelines, but it looks like we've got some pretty strict guidelines for measurements. And the one that's most concerning to me that I think could be harmful to the public is the way that they're asking us to measure the main floor square footage if any of the square footage is below grade. And so it asks us to treat it as if it's a basement if any of the area on the main level is below grade. And previously, that's not the way we have done things. We've always reflected the market reaction. We've always reflected how the market has asked us, the local market has asked us to do things. Based on the topography in the state of Tennessee, I feel like this is going to be very difficult to do, especially in Chattanooga, and I'm sure in other surrounding cities, counties, to do this without having any square footage on the main level. And I wanted to see if anybody had any thoughts on this and if there's any ability to discuss it and possibly make a rule to opt out of this particular guideline and make a rule of our own, because I think the state has the ability to do that. And I feel like it's going to protect the public to do that as well.
I will say this. We have been requiring our appraisers follow ANSI guidelines for probably close to 10 years. And whenever this comes up, our recommendation to the appraiser is, and this comes up a lot, split levels. Because there's typically maybe one small portion of the split level that's, below grade. there are other split level properties out there that you can compare the property to that probably have the same condition. And as appraisers, there is nothing that says that you can adjust a quote-unquote basement or below grade at the same level that you adjust the upstairs if the market data supports it. So that we've been doing this for a long time. It's never been an issue. I think that, you know, if you look at it and make your adjustments to your below grade with like properties, that adjustment could be exactly the same as the above grade adjustments.
On the frequently asked question 14, the ANSI standard requires the area that is partially or wholly below grade to be counted as a basement. It defines any portion at all, to be counted as below grade. So that means if there's a foot below grade on the right rear corner, we're supposed to count that as a basement according to this ANSI, and that's not the way the market has been followed. The market reaction has been followed this whole time. That's not the way we've been, doing things, is to count, not to get any above grade square footage. Is that how you've been doing it in the past?
Yeah, I lived through this. I had a split level house that was all but about 1 foot of one corner that had dirt piled up against it, and every appraisal I ever got treated that as basement.
Yeah, ultimately, this is a GSE adopting a standard. I don't think we have any jurisdiction to change or edit that at all. So, correct.
That's sort of the way I look at it too, because this is specific to GSEs, there, when you get into an appraisal concerning litigation, Department of Transportation type of work, you're getting into different scopes, and I think it falls more under the scope than anything else, and we need to be careful about putting a requirement out there for measuring.
And there are several states that follow this standard.
Well, FHA, VA, and USDA are not gonna follow it. So y'all are saying that y'all are doing an appraisal, and if there's a foot below grade, that you're not giving that main level any square footage at all on the main level, any value, and you're putting it in another section of the report.
I can't really speak to that. I would just say that I'd maybe stay away from that type of work, because again, it's a client scope of work, and I don't if you're not comfortable with that, I mean, there's a lot of other things out there. Like I said, FHA, VA, maybe something to look at.
Yeah, I do all of it. I just was curious how y'all were, thinking. It doesn't sound like it. In Chattanooga, there's a lot of homes that appear to be, based on topography, to be that way. And I think the public is going to be, we're going to have more complaints about why their square footage is not considered above grade, when there's only like a foot or two, like you said, on your house below grade.
Yeah, I've been doing this over 30 years, started out doing a lot of single family, and that's always been a question, if it's, how do you handle below grade? So even with this, I don't think it'll necessarily go away. It will help. It will create some uniform measuring tools for certain types of reports, but personally, I think it's a scope of work, and we need to leave it open.
Okay. All right. That's all I had. I just was hoping we could discuss a little bit more.
Sounds like that comes up from time to time. Okay.
Moving to old business.
Okay. Yeah, we'll move into old business. This involves short-term rentals. just as a matter of protocol, like to recognize Assistant Commissioner Martin, who has joined us. He's actually been sitting back behind me for a little bit, but this is the first chance I've gotten to officially recognize him. Pertaining to the short-term rentals, this board has discussed FAQs, and a number of you have called to, ask where we stand on that. We've done quite an extensive review. Some of you we've had conversations with, but the position of our position, I should say, is making a recommendation of not posting these FAQs, and I'll let Assistant Commissioner Martin expand upon that.
Hey, thanks, Michael. I thought I'd come up here. I know how the view can look from the camera when you're sitting in the back of the room, so thought it would be a little more comfortable. So first, just want to say good morning and appreciate our commission members being here. Always great to see you all. I try to pop into the board meetings when I have the opportunity. Of course, we've got no shortage of them. Have quite the busy week. I know Michael in particular has a few. So as Michael mentioned, I knew that there had been some conversation about this topic at some previous meetings, and in between meetings, we had the opportunity to have a lengthier discussion about this topic and include legal in that. And I think it's been a very positive conversation to have, and I want to thank the chairman in particular for really raising the issue of competency, which is where I think we should focus some of our attention. But as it relates to the FAQs, we do feel that it would not be in the best interest of the board, or it would not be in the board's best interest to move forward with publishing these, primarily because there's not really a national standard, certainly not a state law or state rule that speaks to what licensure someone would hold to go out and perform an appraisal of a short-term rental. And so, I've made this point to a couple of you, but I think we can all agree. When members of the public or even members of the industry find an FAQ on a government website, right, that can oftentimes be held out as it should be, could be held out as an official resource. And so our concern is that if we did move forward with publishing, that they could be seen as that when there's not really a standard of authority present. So not necessarily that we have issue with discussing the topic. I think it's a new thing and a worthwhile topic to have some discussion about. I think the competency piece was a very positive thing that was a product of that conversation, but would advise caution on moving forward with publishing them at this time. So happy to have some conversation, and thank you for letting me pop in.
We appreciate your input. Any time in the past when we've done FAQs, it sort of is passed along to make sure our thought process is correct. And as I conveyed to you, our main concern was competency, and this was an issue that just keeps popping up with this property type. And as you indicated, even though in the Gatlinburg, Pigeon Forge area that these have been around for a long time, this property type is relatively new. And one thing that I've seen in reviewing for license upgrade is even though they've been doing it for 20 years, doesn't mean that they're doing it correctly. And as the public is starting to recognize this property type, and there are several investors going out and buying these properties, as a valuation community, we need to exercise caution in how those valuations are done. And competency, just like any other, if it's a shopping center, whatever property type it is, USPAP requires us to be competent, and we need to communicate that competency to our client. And so discussing these FAQs have at least opened up the discussion of, okay, what's your competency? when you perform an assignment like this?
Yeah, I'd like to speak on it as well. So the FAQs were never meant to restrict any license to not be able to do these. We put these out there because we've seen some different issues through review work here, review work outside, that there's a lot of appraisers who are doing these and maybe not, or they're not trying to make a mistake, or it's just they don't know what they don't know. They're not competent to do them, and they're putting their license at risk. They're putting their client in jeopardy. And again, it just comes from a lack of knowledge. So this was only meant to put out there as guidance. And I definitely can see your side from this, from that. Even a FAQ, even though it's out there for guidance, may be construed as more. And so that's fair. That definitely was not our intent. And I think within the FAQs, I know they weren't published, but it never said that you had to be a CG to do these. The only statement in that was that if you're valuing the entire business operation, allocating or if you're valuing the going concern and you're allocating intangible value, that that may cross over into the commercial side. But it never once said that you had to be a CG. In fact, if you can do these and you can do these competently, and you feel like you can comply with USPAP and give your client what you're looking for, and you're a residential appraiser, a licensed appraiser, you should keep doing these. We're not saying that at all. Again, you're not the appraiser that we're talking to. This is information for people who maybe are not familiar with this property type and are unknowingly making mistakes that, again, put themselves in jeopardy. And so, like Commissioner Garrison said, all we wanted to do was provide some information and get this out there. And so at a minimum, I think that's been done, and was really our goal throughout the entire process.
Michael, you have anything to add? Or
No, I don't. If the commission is satisfied with the conversation, and
y'all have any other questions for me? I appreciate your comments, Commissioner Mansfield.
I think we're good. Thank you. Thank you,
Chairman,
coming to the meeting. We appreciate you very much.
Mr. Chairman, we do have a request from someone in attendance online to discuss CE credits and attendance of conferences. I believe Dr. Jane would be a primary member of this discussion. Before we get there, sorry, we have a public comment about the FAQs that we would like to recognize.
Is somebody here?
Thanks, everyone, for allowing me to come up and speak today. My name is Eric Collinsworth. The main thing that I wanted to address regarding those FAQs, as I read through them, I thought there were some good points that were brought up, but I think there's been some scare brought about regarding the comment that if it gets over into a business valuation, I think it may have been question 2, it indicated that those are more reserved for a certified general appraiser. So I just wanted to kind of settle some of the scare that's going on around the state right now regarding licensure status, if you have to be certified general, certified residential, or licensed appraiser. Because I printed off, and I printed this over the weekend. I doubt seriously it's been changed since then. But I printed off from the state's website general information regarding who can appraise what. And it basically says a state licensed real estate appraiser can appraise non-complex 1 to 4 family up to a transaction value of $1 million or less. A state certified residential appraiser can appraise all types of non-complex 1 to 4 family without regards to value. And then a certified general appraiser can basically appraise any type. Now, having read that, then that kind of put a little thought into my head. Okay, what's complex? I could not find it defined anywhere on the state's website as to what a complex assignment was. So then I looked at USPAP. USPAP does not define what a complex assignment was. So at that point, I'm hoping we all can agree that it becomes an assignment condition from your client as to the complexity or the definitions. So I looked at, considering the majority of these are done for banks or institutions of some sort, I looked at their guidelines, and they actually, in CFR 12, Part 34 for OCC, Part 225 for the Federal Reserve, and Part 323 for the FDIC, they all three do define a complex appraisal. And it's defined as complex appraisal for a residential real estate transaction means one in which the property to be appraised, the form of ownership, or the market conditions are atypical. So I believe one of the counties we have in question basically is Sevier County, Gatlinburg, Pigeon Forge, Sevierville area. And I'm hoping to help settle some nervousness and tension. I'm hoping everyone can agree that in those markets, those properties are not atypical. I mean, they are the vast majority of those markets on 1 to 4 family. So in that case, if they're not considered complex, then they would be non-complex, which would mean a licensed appraiser or certified residential appraiser could do them. And at that point, it comes down to competency and education and training. And I kind of want to turn it over. I think Creighton Cross also has some points to bring up about that. Yes.
One thing that you mentioned was property ownership interest. In the definition that you gave.
Yes.
And I think that's one thing that is probably the biggest question mark with this property type is what interest is being valued.
Sure.
And that's where the complexity, I think, shifts beyond a typical residential appraisal.
Right. But it's typical in that market, that type of ownership for the short-term rental.
But you must, and USPAP requires this, must identify that interest.
Yes.
And is it a fee simple interest or is it a going concern interest?
Absolutely.
And in the reports that I've seen, that is not explained and that's not communicated.
And that's where I'm getting
and
to.
And it is an education.
Yeah,
I'm 100%.
Yeah, that's where I'm going to. I think
that.
It comes down to the education of the appraisers. Mm-hmm. And I think really, if we're going to do some good for the state of Tennessee and for the appraisers in the state of Tennessee, if we're wanting to set a precedent for the rest of the country, I think the thing we need to do is to develop a course to be able to teach that to appraisers so that they do become competent on that.
You know, under the current guidelines, we're not given a lot of flexibility by the GSEs, and some clarification would be would go a long way. It's it really makes it difficult for appraisers to do this. I'm not saying that it can't be done. It just makes it difficult under the current framework, and so I think that's where the issue is. Rex alluded to interest or to the interest appraised, and I mean a lot of times in areas, in Davidson County, it's really a highest and best use issue, and it comes down to legal permissibility and what's allowed. And so again, it's we're never once said that a licensed or certified residential appraiser shouldn't do these. The FAQs alluded multiple times to competency, and again, just trying to make appraisers aware of the nuances involved. A lot of times these do transfer with FF&E, or if the owner might be a superhost, and so their rents are higher and their occupancy is higher. When those aren't maybe directly related to the property, you can give your client. They're looking, Fannie Mae and these GSEs they want to secure these loans with real estate only collateral, and so if you can provide them with the real estate only component on these forms, then again, you should keep doing that. I don't think that was ever our intention.
Right, and getting the proper education to the appraisers that want to value these type of properties and take these kind of assignments. I think that's the key, is to show them how do you take a going concern and you back out the FF&E and you back out any other applicable deductions to come up with the value of the real estate. That's the key to getting that out there.
Thank you, Chairman. Sir, first of all, I just wanted to say I've been to a lot of these meetings, and we don't get a lot of public comment. So thank you very much for taking time out of your day to come and be part of the conversation. I wanted to just clarify a couple points. I know Commissioner Mansfield and the Chairman mentioned this point as well. I realize it wasn't the intent of the FAQs to be held up that way. I think you've all, I appreciate you making that very clear. But just to clarify again, the administration felt that the FAQs being published in that way could be held out as somewhat anti-competitive to say hey, you have to hold a certain license type when really it comes down to a competence issue. So I just want to clarify that again, and I think the board's made that clear.
Absolutely. And I like I said, I think Creighton may have a little more discussion possibly also from an education perspective. I don't know, Creighton. Yeah. But I appreciate y'all's time allowing me to come today.
Thank you.
Creighton Cross, again, certified general from Knoxville, Tennessee. A lot of what Eric said, I don't want to just rehash. Over the last week and a half or so, I've interviewed about 30 appraisers, 2 attorneys, including an E&O attorney, a couple banks, a couple real estate agents that work in Sevier County. I cover that area tremendously. We do hundreds of short-term rental properties annually. I take pride in the way we do it, try to do a good job, try to educate my appraisers, try to educate the real estate agents in our market. I do believe this is an education opportunity. I don't know how the state handles that from creation of a class or how that would look. But I do believe that's something that we need to address so that the public is aware. I have taught basically it's like a 2-hour seminar for real estate agents in Sevier County that covers the issues facing these short-term rental properties. The going concern component, I do believe exists. I've really struggled with understanding it. Zach Doris is really, really smart and handled that. He talked me through a lot of his thoughts on it. There's some very significant differences between Sevier County and Nashville, from zoning, legally permissible uses, things of that nature. Apparently complexes are being built in Nashville, zoned commercial, that are all nightly rental, whereas we have individual cabins, 2-bedroom, 3-bedroom, 18-bedroom, 22-bedroom cabins with indoor pools. At some point, that does appear to be a baby hotel. AirDNA is an opportunity for people to find this data and research this data. Airbnb has recently indicated that between Nashville and Sevier County, Davidson County and Sevier County are like number 1 and number 2 in the United States in nightly rentals. In discussion with the tax assessor in Sevier County about this topic, along with the personal property component, there needs to be some type of statute set for the personal property to be allocated. I think in my review of other appraisers doing this type of work in my market, the personal property adjustment, all of these homes are selling with furniture. That needs to specifically be addressed, and I think that would be an opportunity for frequently asked questions or an advisory opinion of some type from somebody. It's a serious issue, and as you mentioned with the superhost situation, there's almost this intangible going concern, blue sky value that's being transferred. The argument is typical management in the market. That would be my only argument to that, is that we're valuing this property under typical management. Same with an apartment complex that has elevated rents month to month versus long term. There's an added management, maybe some type of shortfall if it's undermanaged, that we would analyze from a commercial perspective. I would love more guidance and more discussion on this. Outside of just, it needs to be a competency issue. Rex, I know you're in that market as well. East Tennessee has been dramatically impacted with these short-term rental properties. And that's really all I had to say. I would like clarification on the definitions that were mentioned. Eric defined complex property, defined certified residential appraiser. On the Appraisal Foundation website, there's a different definition for certified residential appraiser. I just want to make sure I'm not misunderstanding this, where the state of Tennessee definition says all types of non-complex one-to-family properties. In the Appraisal Foundation definition, it says certified residential means a person who is qualified to issue an appraisal report on residential real property of 1 to 4 residential units without regard of value or complexity. So it seems that the state of Tennessee's definition varies from the Appraisal Foundation's definition, possibly a little more strict in what the actual certified residential appraiser can and cannot do. And I didn't know if that's something we could look at. I could be mistaken. I just want to bring that to everybody's attention.
You can take a look into it. What was, you said the certified residential definition?
It was just the certified residential section
Okay.
on the state site and on the Appraisal Foundation site. Because of the unique nature of this, there are some limitations in the definition of licensed appraiser on the Appraisal Foundation. I don't know that complex properties would qualify. If we can define these as complex properties or not, that's a whole nother discussion. And Eric spoke on that already. I did reach out to Freddie Mac. I reached out to Danny Wiley. Got some comments. He said that he's specifically going to look into Freddie Mac compliance to to try to check on that, get some type of opinion back on how Freddie Mac would look at that from GSE perspective. I emailed and called and left a message with Lyle Radke at Fannie Mae. I did get a response back from them. It's lengthy. I don't want to read it. But my concern in this whole topic was that the majority of the properties we're seeing, and I think I was keeping track of it and I lost track, but I was getting 20 to 60 bids a day to appraise short-term rental cabins in Sevier County. Just that one county, just my one office. Obviously, we can't do that type of volume. I know other appraisers are doing them as well. But every one of those orders coming from a federally regulated institution is requesting that short-term rental on a 1004 Fannie Mae form. So I think the guidance needs to be from the GSEs on how that assignment condition should look. If they're still ordering them, but if we deem that they are commercial, obviously a certified general could then do them on that form, but that's maybe not feasible. I don't know that there's that many certified general appraisers that do Fannie Mae reports. I do. It just happens to be a part of my practice. So that's a question I would have is there any way that we can have guidance or request guidance from the GSEs and then educate lenders? Because that's the other avenue that we're seeing is that lenders don't understand this. Real estate agents don't understand this. I have to explain on a daily why my appraised value came out 5% below a contract price in some instances because I had to extract and allocate, according to USPAP, any of the information pertaining to personal property and furniture, maybe business value. So that's my question to the board is there a way that we can create education for the appraisers and the lenders and the real estate agents in Tennessee? And what does that look like? And then secondly, what can we do to get advice or guidance from secondary market GSEs?
A couple of things. Interagency guidelines, I think, specifically say that a lender cannot lend into the going concern.
Correct.
It has to be
allocated and extracted by the appraiser.
In what I've seen, and I've talked with lenders on this, you have the sales comparison, you have the income approach up here, and your cost approach is down here. What property interest does a cost approach always indicate? The fee simple. So there's an obvious difference between sales and income that is basing it on the market in the income versus the fee simple. One thing I've seen is there's no good reconciliation to explain why that is. And that's a USPAP requirement.
Supply and demand, it appears, in the market.
If that's, what component is that? And when you get into on the commercial side, you look at Walgreens, you look at Dollar Generals, you look at some of those.
Risk.
It's risk. And that's the one thing. And talking with lenders, I've asked them, what is their loan to value on it? And they said, well, we understand that it's not good, so we're looking at a lower LTV, 60 to 65%. So they're recognizing the risk. Mm-hmm. The investor's obviously recognizing the risk. What I've seen in appraisal reports is risk isn't being considered.
I agree.
And that is the biggest reason why I felt that this was something that we needed to discuss. And it's opened the door for discussion, and I totally agree. There needs to be a class.
Yes.
And I've talked with different providers saying, this is something that needs to be addressed. And I've talked with the chairman from the Appraisal Institute for the body of knowledge. This needs to be addressed because right now the market is so good, you can make a mistake and still win. It's when the market turns, and that's when the public gets into trouble. The other side is you talked about that the client requests a 1004 form. Whose responsibility is it to determine the scope of work?
It is a relationship between the appraiser and the client.
But as USPAP says, who is the ultimate?
Appraiser.
The appraiser. and so that's a communication with a lender. And I've had lengthy discussions over the whole STR with some lenders. And I think at the end of the day, they realize that they may need to relook at how these are being financed. what's interesting, I asked them on the LTVs, the LTV of the cost approach is much higher.
It is.
And I encouraged them to always ask for a cost approach and getting it so that they can
analyze that. Yeah. I do have one comment on that I've seen, and I don't know if the board has a reaction to it, but in agricultural related commercial assignments, and I'll pair this together, we have high demand in the poultry industry currently, and we are starting to see cost approach with a positive economic benefit. So we have in the cost approach, we have depreciation that is physical, functional, and external or economic, right? Those are your three. We're seeing a positive adjustment in the agricultural business because of demand driving up the sales and the income on these poultry farms. The cost approach significantly low. And those are leases. Those are long-term leases with, the investor poultry company. So if we look at that from the investment standpoint from a short-term rental property, where our cost approach in the example is $500,000, but the sales comparison and the income support $900,000, we extract our 5% for FF&E in this case, can't analyze or identify going concern in that case. We still have a $500,000 fee simple cost approach as if vacant. Then we have our sales and income at say $800 in that situation. I don't know that the guidance or that education, because we don't have training on this fully, is to make that positive economic adjustment to the cost approach. And that's something for discussion. Yeah. If we're not doing frequently asked questions or advisory opinions, we need to educate ourselves to be able to educate the appraisers and inform the public to be able to protect everybody in these transactions.
And I think if you can't identify, you need to explain.
Correct.
And that's
what we're not. Highest and best use.
Highest and best use.
Yeah. I was reviewing zoning in Sevier County. Zoning, which you have Sevier County, then you have Pigeon Forge, Sevierville, and Gatlinburg, each have individual zoning areas, but there's overlap where most of the zoning in all of Sevier County and the cities allows for short-term rentals. There's an R1 zoning in Sevierville that prohibits it. There's a significant, that's back to, is there a going concern value? There's a significant difference between owner-occupied rental cabin and the one across the street that happens to be zoned. So that's up for consideration that the appraisers need to be aware of. I was told in interviewing appraisers in Nashville that the majority of the nightly rental properties that are in Davidson County, I don't work here, so forgive me if I'm wrong, are zoned commercial. So that does add an element to our highest and best use as vacant for the appraisers to consider in that situation. Obviously, if it's short-term rental, individual condo, that's a whole nother ballgame. But that's all I have. I just thank you for your time, and I certainly appreciate what you guys have put into this and what the legals put into this and the appraisers have put into this, because it's a topic we need to address and get clear soon. Okay, thank you.
Thank you.
Mr. Chairman, I just want to make one more comment. So I'm going to work with Michael and some of the other program folks. I think this meeting and some of this conversation has shown that there's certainly a need for some courses or for some additional education on this topic, regardless of how someone is licensed. So we'll kick those options around and talk about if we might be able to solicit some of that feedback from some of our course providers.
Thank you.
Yeah, also, in the meantime, I would suggest to you all that you reach out to your national governing bodies and or trade associations and ask them to start a nationwide conversation on these guidelines, because absent of a statute or guidelines, there's not much discussion that can be had, or not much action, I should say. We can talk about it till it's blue in the face, but can't do anything about it until those things are done. So okay. I'll go back to my previous request. We have someone on the line, Ms. Kaylee, who would like to discuss the merits of conferences and the review process for which those are taken. So to give you a little background, and Dr. Jane is aware of this as well, Ms. Kaylee submitted some CE hours for a conference that she attended. She was unable to procure, I think, really enough of the course material that was needed to really warrant a proper review. So at this time, if it's all right with you, sir, I would ask Dr. Jane to kind of lay out his process if he can. Actually, I know he can, but to lay out his process. And then Ms. Cayley is on the line, so I believe that she might have a question or two. When you're done with your process, if you would like to address Ms. Cayley, feel free to do so. If not, I'll take over when you're done.
Absolutely.
Thank you.
So we try to apply a very high standard for approving or pre-approving, whether it's a full a course or a conference. And what we are requiring vendors to submit is a copy of the full course content or a video recording or any form in which reviewers and the commission staff can ensure that there is quality control and quality assurance. The quality of education going out to the appraisers is of sufficiently high quality, so we are serving the public in the best and protecting the public through the proper appraisals. So when the materials are not provided, the typically review committee sends it back to the commission staff, who then request those materials back from the vendor. And almost 99% of the time, the vendors are able to provide the full course content for the committee's review. And that's the process we have followed for fairness and to ensure that everybody has to follow the same rights. So there was a specific case, I think, which there were no contents available, and there's no ability to assess the contents of a conference. It becomes very difficult to even assess whether the conference was about appraisal or not, and if it was, whether the topics for which the credit is being requested is sufficient is there a proper match between the number of hours and the amount of appraisal content covered in the conferences. So unfortunately, in this case, I think when the materials are not provided, those are the circumstances under which the review committee does not approve the courses without the full content being reviewed. I hope that clarifies the process for all the vendors. We strongly encourage all the vendors to provide. There is a lot of flexibility the review committee has in terms of what format they accept the course content from. So it could be a printed copy or a PDF of the materials or PowerPoint slides, or it could be video. In this hybrid world, a lot of education is happening in the virtual environment, and we completely understand that. So if there's a video recording and there's a link, the committee is also able to review those types. And I think
Ms. Cayley, do you have any questions?
Well, yes, I do. Can you hear me all right?
Yes, we can.
Okay, thank you. I appreciate the opportunity to attend the meeting and to discuss the continuing education credit for conferences. With a point of regard to attending national conferences, this is the third time since 2012 that I have attended conferences and have applied to the Commission for Continuing Education. In doing so, there is an application, of course, on the website to fill in the application and then attach the particular information regarding what's going on at a conference. And again, most conferences are 2 or 3 days at a given location. They are not a one-course conference. They are usually divided up into sessions. Our conference, particularly this particular conference that I applied for credit, had such speakers as Lyle Radke from Fannie Mae, Peter Christensen, who is an attorney for liability. He was with LIA Insurance and now has his own firm and discusses bias and that sort of thing. I attached with my application the bios of every speaker. There were 10 speakers in the 2 days. They were 1-hour sessions. as I say, from Fannie Mae to Peter Christensen to professor of economics from Texas A&M. They were all known speakers and talked about either market conditions, bias, current Fannie Mae guidelines, and of course this was for a particular conference on relocation, which I'm a relocation appraiser and member of this organization that put on the conference. All of that was documented with my application, and then I was asked for further information. I put together all the information because I was on the conference planning committee prior to the conference the year before, put all that information together, sent it in, and was still denied any information or any continuing education hours. I have done this since 2012, 2 other times, and because of the documentation, was able to present substantial information that credit was given. And I just don't understand why this time, if there have been changes in the guidelines for what you are needing to see at a conference, we need to put that on the application so that other people not that have never applied before are aware of what the guidelines are and what other information can be presented. When you present a synopsis or the program book or the bios of all the speakers, I don't know what else you can present to indicate what you have taken away from a 2 or 3 day conference. And that is my concern because, as I say, the speakers were relatively, well, they were all professional. They were all speakers that concerned themselves with the market, with appraising, particularly relocation appraisals, which is a different animal in itself. It's a niche product. And I don't understand what else is needed to indicate when you attend a conference, what else is needed to obtain CE credit. If we could discuss that or what you're specifically looking for, then I think it would behoove the commission to put those specifics on the application so other appraisers would know what specifically needs to be included as far as proof of attendance and proof of education for a period of 2 or 3 days at a conference with regard to the appraisal field.
Yeah, that's thank you for your additional information that you provided. I think this have been clarified to most of the vendors and the conferences who try to pre-register that they want to provide full course content in terms of the examples could be PowerPoint slides, including our website or some chapters that they are covering. So we have received these type of materials from all of the vendors who have received approval for their courses as long as I've been serving on this commission. And again, to re-emphasize, the quality assurance is very important. Without viewing the materials, simply by submitting the bio, it becomes difficult for a committee to review the course content and approve the course as a of a person.
I guess the difference here is it's actually not a course. A conference is a group of sessions of various topics, and each topic is a specific entity in appraisal or in the appraisal profession. So it's really not a course that we can say, here's the course subject matter. It is a matter of this is what the professional speaker spoke about for a given hour on whether it be Fannie Mae changes and rules and guidelines, or whether it be bias and what to look for, or how to protect yourself as an appraiser in liability and that sort of thing. So if there's no course material, it's not a course. It is actually a session in a conference. and each session is whatever it is, an hour long or 2 hours long or whatever. So there really is not a course handout. All that an appraiser can provide from attending a conference is the conference program book, the bios on the speakers, and a synopsis on each session that is given. So obviously, if you need more than that, I'm not sure that conferences would even be considered as something that you could gain continuing education for if we need more than that. So maybe there just needs to be a decision made on if conferences are even appropriate to get continuing education or not, just so there's not a confusion in the future.
Ms. Cayley, if I may, this is Michael Schultz, the Executive Director. We have had a number of different conferences submit the requested amount of course or a requested amount of material for approval. So generally speaking, this responsibility does not fall to the appraiser. Personally, this responsibility is on the conference organizers themselves. And if they don't have the ability to submit the required material, then there's not much we can do about that. We certainly don't want to be burdensome to all of our licensees by requiring them to personally get all of these PDFs and handouts and whatnot. So that's why that burden is incumbent upon the conference organizers.
I understand. And now that you've explained that to me, I understand that's what you're doing in this time frame. In 2012, I applied for a conference to the commission, sent the same type of information in, and had no problem getting the 10 hours of CE credit. In 2019, I did the same thing from the same conference. This is the Relocation Appraisers Conference. It's always held in Texas. I did this. I got the credit in 2012. I got the credit in 2019. And now, again, having done it, submitted the request this time, it seems that perhaps the way you all view things, if you need it to come from the organization or the conference people rather than the individual, we need to know that, because that's not how it has happened in the past. And that's basically my only point of contested, is that if the guidelines have changed and if that's what you are needing, then we need to know that, because this is a national organization and we've always been told that you can go back to your states. And in fact, Texas has reciprocal agreement with 15 other states. And it's just a given. If Texas agrees to this, then whatever state you are in that has the reciprocal agreement agrees to the continuing credit. I have always just never had a problem in applying through the commission through Tennessee since 2012 until this year. So if the guidelines have changed, or you are needing the conference to the organization or the conference to be the one to apply to Tennessee, then we need to know that, because I'm on the board for this organization, and as a past president, we need to know that. So I guess that was just my point of concern, is obviously the guidelines have changed in how you're looking at conference credits, and we need to know that.
Yes, I'll point this one out in a conference that I've attended to for several years on and off. It's the Aero conference. It's a conference for the regulatory side of appraisals. This past year in October, you had to communicate to them that you were going to attend and wanted continuing education. And in doing so, they would send you the proper information and record your attendance. And with one thing too, with every CE class that you may take, there is an attendance sheet that you're required to sign, and then that provider communicates that and certifies that you did attend that conference and attended for the amount of time that the state would require. And at the Aero conference in years past, we didn't have to be didn't have to communicate to them that we wanted continuing education, but just this past year they did. And so I don't think it's a matter of anything changing. It's just really trying to tighten up that continuing ed isn't, being passed on without the requirements being met. And in every conference, and I've been to other conferences, that burden falls on to the conference provider. It's always approved with each state from that conference.
Well, I do appreciate the information, and I will pass that on to the Relocation Appraisers and Consultants Organization. And next year, when we plan our conference again, we will do a different avenue and apply as a conference rather than tell our individuals to apply. Thank you so much for the opportunity. I appreciate your help and the information on continuing ed. Thank you.
Thank you. With that, I think I will entertain the most favorite motion.
Second.
Very good.
Motion adjourned has been seconded.
Yep.
Thank you all.
Thank you.
You can stop this recording.